Have you ever read a story about how a judge screwed up a Second Amendment case and asked yourself, how on earth did that judge mess up and not honor our right to keep and bear arms? Well, there's many reasons for this. I want to explore judges. I know this is going to be a little geeky, but it's important for us to understand judges if we're going to persuade them to help protect our right to keep and bear arms. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. We're working really hard to try to get to 100,000 subscribers because we think it'll make a big difference when it comes to the social media algorithms. We have many different ways we go about protecting our right to keep and bear arms. One of them, of course, is in the court system. It's not the only way, but one of the big ways is in the courts. Who makes up the court system? Well, a big part of any court system, obviously, are the judges. We often talk about the United States Supreme Court justices, who are 9 judges that sit in the U.S. Supreme Court in Washington, D.C. But there's hundreds and hundreds of other judges, state and federal judges around the United States, that when you're trying to vindicate your right to keep and bear arms, often we have to go in front of judges other than the U.S. Supreme Court, because you don't get to the U.S. Supreme Court initially. That's very rare to do that. You have to usually go to lower courts and work your way up through appeals before you go to the U.S. Supreme Court, if ever. And I just want to talk a little bit about a sort of inside baseball with you for just a couple minutes about some of the issues that I think the pro-Second Amendment community faces when going in front of some of these judges, both federal and state judges. And these are the sorts of things that I'm going to explain an inside baseball approach, because I've been in front of countless judges and have worked for judges, and I'm familiar with the process of judging and how they become judges. So I want to share some of these insights with you, because I think that might help you understand why sometimes we get these terrible Second Amendment rulings from judges that may not appear to be particularly bad on the Constitution, but sometimes we get terrible rulings. I want to discuss some of the problems that we do face with dealing with some judges in the United States. The first thing to keep in mind is what I call caseload bias, which are the types of cases that judges often see. Keep in mind that most judges in the United States, including the U.S. Supreme Court, they actually see criminal cases as well as civil cases. Criminal cases are people that have committed crimes, and if they're found guilty, they go to jail. You know, it's Law and Order. It's all the TV shows you've seen, courtroom dramas, people going to jail for committing murder. So most of the cases that judges see in the United States are criminal cases. They also see civil cases, which are lawsuits, but most of these lawsuits are commercial in nature. They're the sort of thing that I spent most of my career doing, which is fighting about large sums of money over contracts, trust indentures, bond offerings, security offerings, whatever it is. You basically have people fighting about, issues in the commercial side of things. And this, of course, usually involves contracts and money and things like this. So I only bring this up to say that it's very rare for a judge to see a constitutional case involving the Second Amendment. It's just not that's not generally what they see. The bulk of what they see are criminal cases. And when you're dealing with federal courts, by the way, the types of criminal cases that those federal judges usually see tend to be particularly bad and gruesome, meaning most ordinary crimes, even most ordinary murders, rapes and robberies tend to be handled by state courts, lower courts, local district attorneys. But in the federal system, if you're in federal court on a crime, usually it's a big time problem. You're the head of a gang. You killed a lot of people. You were a big drug dealer. Things along these lines. You were engaged in a RICO conspiracy. All sorts of big time things. So the reason why I bring this up is most of the time when a federal judge sees guns in his or her courtroom, it's guns being misused. And that is a big problem because they rarely ever see a case where guns are used favorably. Again, usually the cases they see are criminal cases with people using guns, are misusing the guns to commit some heinous crime. So, judges are people too. And if they see guns always being misused in their courtroom, they have a bias against guns. So unless a judge is a gun enthusiast, odds are, the judges are going to have this caseload bias against guns by virtue of the criminal cases using firearms that they see day to day in their courtroom with people pleading guilty and, going to jail for bad, gun related crimes. So that's the first thing. And relatedly, the one type of case that most judges don't see, it's semi-rare out there. It's not semi-rare in that it doesn't occur. It's semi-rare that it goes to court. And those are, cases involving, legitimate defensive gun uses. Certainly you do have cases involving defensive gun uses that we're all familiar with. Kyle Rittenhouse is a famous example. The case down in Florida involving Trayvon Martin is another one. But by and large, most defensive gun use cases get handled before it ever goes to trial, rarely goes to federal court. Again, a lot of times, the prosecutors take a look at the defensive gun use and they clearly say this is clearly defensive gun use. You've got a 75-year-old man who used a firearm to shoot a 25-year-old known member of a gang, at 3 a.m. in his kitchen, things like this. And those cases don't get prosecuted because obviously it's a pretty clear case of defensive gun use. So the judges never see the good use of gun in those types of cases because they never get to court. They get handled and never get charged. So again, you have this one-sided ratchet bias against guns in the courtroom because most judges, when they see guns in the courtroom, it's guns being misused. Then you go on to what I call the judge's professional background bias. And what I mean by this is a lot of the judges in the federal system are first of all, you have progressive liberals that think government is a force for good. So anytime they can expand the role of government in our society, they think they're doing a good job. I think Ruth Bader Ginsburg was a classic example of this. She actually thought government was good and almost always ruled in favor of government over individual liberties, unless, of course, it involved a political individual liberty that she politically liked, such as the right to an abortion or anything associated with gay rights and the like. But by and large, if it involved firearms, a lot of the progressives simply want government to have a monopoly on guns, and they're going to view courts as a rule to help get that done, and they're going to always rule against the Second Amendment because they think they're doing their job as judges, even though I don't think that's the way to do it. Then you have what I call the good judges, but not all the good judges, meaning conservative judges, Trump judges, Bush judges, are necessarily good on guns, and I'll tell you why. And this is a dirty little secret in the conservative community that I don't think it's discussed enough, and that is the danger of law and order conservatives to gun rights. And what I mean by this is there's a lot of sort of good conservatives out there who would, generally speaking, be good on a lot of issues that maybe Republicans and libertarians and conservatives support. So again, a lot of these law and order conservatives, they generally think that the government are the good guys, that the U.S. Attorney's Office is the good guys, that the FBI are the good guys. And as a consequence, they are much more inclined to rule in favor of the government because they think the government are always the good guys against Second Amendment rights, not drawing that distinction between, violent thugs with guns and ordinary law-abiding citizens with guns. So I think a lot of law and order conservatives can be bad on Second Amendment, even though they maybe have been appointed to the bench by Republican presidents. Of course, when it comes to protecting our right to keep and bear arms, I think the best type of judges are those that are constitutionalists or originalists. Those are trying to abide by the Founding Fathers' vision of the Constitution, including the Second Amendment. Those are people like Clarence Thomas. Those are obviously best for the Second Amendment and the rest of the Bill of Rights. But again, those are only a percentage of the federal judiciary. There's plenty of other people out there. And last but not least, you have what I would call the final category of judges. And again, I'm being very general here, but it's just to help you think about judges. The last category is what I call just careerists. These are people that want to be judges because they like to be referred to as Your Honor. They just view this as a good job. They don't necessarily have any political bias or anything like that one way or the other. They just like the fact it's a good job, and there's a lot of other jobs they don't want to be doing, so they're happy to be a judge because in many instances you don't even have a boss, right? You're your own boss. And if you're a federal judge, you can't be fired because you have a lifetime appointment to the federal bench. The next thing to keep in mind when it comes to judges for the last several decades, there's this institutional memory I would describe that we're still trying to deal with. And that institutional memory is that the Second Amendment is a second-class right. And I think that's how it's been treated for so long. So even though there are judges out there that have read Bruin, Heller and McDonald, I think their bias and their institutional memory continues to teach them that gun owners should lose and government should win. So I think, we still are dealing with this institutional memory, and it's going to take time to turn the Second Amendment into an equal right in the court system. I think we will get there, but it is a lift. It does require work, and that work, I think, is being done right now. The last thing I want to mention is what I call the patent law problem. This is extremely geeky, but I'm going to give it to you anyway. There's an unusual type of litigation that we often see in federal courts, or we don't see it a lot, but we do see it. It's called patent law. Patent law, of course, involves inventions. Under Article 1 of the United States Constitution, patents are the right, a monopoly right to have certain inventions, and sometimes patent inventors fight. So there's a fight over who invented the new camera. There's a fight over who has the new software patent rights. There's a fight over who invented the new trigger lock. There's a fight over the new light. Whatever it is, there's a fight over the new spangled style of sink involving, kitchen sinks. So whatever it is, you will sometimes have patent fights. And that gives rise to two problems that I think is analogous to what we're seeing in the Second Amendment fight right now in many courtrooms. And that is judges, because they don't see patent cases all the time, often make mistakes in patent cases because they're unfamiliar with patent law. It's very unique. It's kind of quirky. And if you don't see patent cases all the time, it's very easy to make a mistake. Same way with Second Amendment cases. There's not a lot of Second Amendment cases in the United States relative to the rest of the caseload involving, like I said, commercial fights over money and things like that. So it's very easy to make mistakes in patent cases because you're unfamiliar with it. It's also easy right now to make mistakes involving Second Amendment litigation because a lot of judges are not familiar with the new system set up by Bruin, which really should not be a new system, but it is because of the way the Court of Appeals went off the rails over the last 10 years involving the law of the Second Amendment. And on a related note, the other problem associated with patent cases in Second Amendment cases is a failure to understand by judges the underlying technology. So in patent cases, if you have a fight over who invented the newfangled kitchen sink, and you have judges that are trying to figure this out, but the judges don't know anything about kitchen sinks or the technology, they're often able to mess up those cases because they don't understand the technology. Likewise with firearms technology, if they're not familiar with firearms, if they don't know the difference between a semi-automatic pistol on the one hand and a revolver on another hand, and a rifle on the other hand, and a shotgun on the other hand, and tubular magazines on the other hand, it's very easy for Second Amendment, for judges in Second Amendment cases to get the technology wrong, just like it is for judges overseeing patent cases to get the technology wrong that's involved with a particular lawsuit. So there you have it. Again, I'm not saying this is an excuse for any judges to get it wrong on the Second Amendment. I'm just trying to put out the practical reality that I think a lot of judges in the United States right now are struggling to understand the way to interpret the Second Amendment and apply it to modern day gun control law. I think we'll get to where we need to be, but it is going to require some work and effort. And hopefully the Four Boxes Diner channel and the sort of work that I do will help America's judges and law clerks and lawyers and intellectual class try to really get to the right answer when it comes to these Second Amendment issues and how to deal with modern gun control laws. And I hope you learned something here. I know it's a little bit geeky, but I think it's important for you to understand what the Second Amendment litigators are up against right now. Okay, if you haven't subscribed to the Four Boxes Diner, please do so, and we'll see you again. The Four Boxes Diner.
Orders up. Table 2A.